Okay, so let's call the lawyers of McDonald's and see if we can work something out here. Yes, is Edwin in?
Edwin, let me check and see if he's here.
Yeah.
Hey, what's up?
Hey Edwin, it's me, Dillard again.
Yeah.
I was thinking since they're pushing the court date out so far, that gives us enough time. Maybe we can get together and get some of this paperwork out of the way. We could see if we can get in touch with her and actually get those documents and see if we, or even if we can settle the case.
Sure. No, absolutely. Let me talk to Brian and see. I mean, do you have a different number in mind? I mean, it sounds like you're going higher, which is, that's not helpful for me, but.
Well, I mean, you guys haven't, you lowballed the hell out of me. I mean, if you can like compensate me for my pain and suffering, and I mean, I'm a reasonable person here.
All right. Well, do you have a kind of a ballpark number you want me to talk to Brian and the client about, or I mean, because the problem is that when we look at the complaint, it's going to be, what Kenesha is going to say and what you're going to say, and nobody else knows what happened. I wasn't there, Brian wasn't there, the jury wasn't there, so it's going to be hard to figure, exactly what happened, and we have to hear testimony from you, testimony from Kenesha. That's going to be long and expensive, and juries might believe you 100%, they might believe her 100% or 50-50. And when we look at the medical records, a lot of your medical records are from past conditions, that go to way before the incident. So
well, that's why I put in there that there was a pre-existing injury that was caused to be made worse. So if a person is already disabled and you come along and knock that person down, and now you done made that person injury worse, you're on the hook for that.
All right. No, I can see that. I mean, if the jury, again, there's a lot of uncertainty because we don't know. Anytime you go to a jury, it's 12 different people from different backgrounds that they have their own views of things. What are they going to say? I don't know.
I understand how the jury work. I've been to the jury trial before, and I do understand how a jury works. But the jury doesn't bother me. That doesn't bother me.
And I'm not saying it should. I'm just saying I don't know. So what's a fair amount to not have to go through that?
Well, if you looked at the paperwork in the beginning when I was with Swift Transportation, Gallagher Bassett, I found out, was the insurance for Swift Transportation.
Really?
Did you see that?
No, I didn't know. I didn't see that.
Yeah. When I first sustained the spinal cord injury, it was with Swift Transportation, and we went to workers' comp court.
Okay, I know that. Yeah,
we talked about that. They settled close to $100,000 in that case.
Oh, okay. I didn't know.
Yeah, but I held out as long as I could, and I talked to their attorneys and everything, and they were like, we want the same deal, we want the $100,000 deal and this and that, and I was like, but I held out as long as I could, and I went on and settled that case.
Oh, that's good. Well, you deserved it. I mean, it sounded like they did not treat you well, and so that's good.
Well, as you know, I'm still fighting that case, so it's in the Ninth Circuit now.
Yeah, I know, but I thought, but you're saying, did you accept the settlement, or that's just what they
I was sort of like forced to settle for the $100,000 in that case, and then I had to pay two attorneys because I had two attorneys on that case.
Yeah. No,
so
that was a difficult thing.
Yeah, they got their cut, and then I went on my way. But yeah, that is what put me on permanent disability, the spinal cord injury.
Right. No, I know that history because I looked at your file and stuff, and that's what I saw.
And so the doctor says no jumping around, no competitive lifting, and no lifting stuff over a certain amount. So when the coffee hit me, well, my body went into a convulsion, jumping around, quickly moving, and that only aggravated and made the injury worse. So we can't overlook that. So now I'm on more pain pills than I was before. At first, the injury was stabilized. So now I'm on more pain pills. I can't sleep. I'm constantly waking up. So I mean, yeah, that need to be compensated for. So I mean, if you guys willing to throw a decent number out there that we can all agree to, then yeah.
What are you thinking of?
It's not about what I'm thinking. It's about what do you guys? I mean, you was ridiculous. You lowball me with $500, and I'm like, come on.
Well, I didn't do that. That wasn't my number. I mean, that was somebody before me, but I think we offered 3,000. No.
That goes to the price of the hospital bills, because I think they're up close to around 9,000. So anything under 9,000 or at 9,000 goes to the hospital, because
I'm not sure.
They're putting that on. I can call them today and get another printout. They putting that on my credit, so my credits has been damaged.
I'm not sure that's correct. Okay, I get that it's hurting your credit. I'm not sure that, because the information I got from the Gallagher Bassett, and again, I don't fully understand that kind of thing because that's not my area.
Gallagher Bassett will give you false information. I got tons of audio on them where the girl was giving me information, and I find out this information they were giving me was not correct. Okay. So for you to tell me Gallagher Bassett said something, I wouldn't bet my stake on it.
Okay. Well, I'll get it in writing and I'll verify it. But what they're telling me is that they checked, and at the time they checked, which was earlier, the medical liens on the record were 0. But they are saying that in order to get the updated liens, they would need your signature on the paperwork. So I don't know. It's chicken and egg. How are we going to get your signature on the paperwork if we don't know what the liens are? So I don't know what to do about that, but that's what I'm hearing from them. So if that's the case, okay, if they do the check, and if the check's accurate and the lien is 0, then you're going to get 100% of that money. It's not going to go to the lien.
Okay, so
and unless I'm misunderstanding something, so just because the hospital sent you a bill doesn't necessarily mean that they filed a lien, or because it's a Medi-Cal lien or a Medicare lien. I don't fully understand it, but it's not the same as the hospital bill. That's my understanding, and I'll check with them again. But what I'm hearing from them is, at the time they checked, and I don't know when they did check, there was no $9,000 lien that they need to pay before giving you the money. So that's why I'm saying you're going to probably get more than you think. You're going to get, I think at this point, you're going to get 100% of that settlement. Now, the hospital might come after you for it, but, that's between you and the hospital,
So, you see that's an attitude of I don't care. It's like, we'll give the money to you. We'll give the money to you and let the hospital worry about getting their part.
But I don't represent the hospital, and I don't represent you.
Yeah, but the hospital is the one who's already reported this to my creditors. I filed bankruptcy back in
Dillard, I didn't say I didn't care. I can't. That's between you and the hospital. So, but you're going to get that money. You're going to get 100% of that money from us. The lien thing is that we wouldn't even be able to give you the money if there's a lien on record. We would have to send that money to the. I think that's how it works. That we would have to send it to the Medi-Cal or the Medicare. So I'm not saying that it's a good situation for you, but it's better if whatever the money is, if the 3,000 goes to you, that's better than if I have to send it directly to the Medi-Cal, right?
That's if you're talking to a person who doesn't give 2 cents about their credit. I filed bankruptcy in order to clean my credit up.
Oh, okay. I'm sorry. Okay, all right. Oh, I didn't understand that. Okay.
So that was me filing bankruptcy in order to clean my credit up. I was cleaning my credit up for a reason.
Okay. No, I didn't understand that. All right.
So now to get all these bills, and they're saying you can pay by credit card or you can do this or that, and I'm like, they got my name on there, and they was like, okay, if you don't pay by this date, we're reporting you to the creditors.
But is their bill fair? I mean, are they? Because sometimes these hospitals overcharge. That's the thing. I mean, can you fight the bill?
Yeah, by taking your client to court and then say, hey, this is a bill that I wouldn't have if your employee hadn't dropped coffee
Well,
on me,
but
so
it's a
you
separate
should
issue.
take care of
If they're
this.
overcharging you, that's not my fault. I mean, it's unfair that they're overcharging
We
you.
understand it's not your fault, but it's your client's employee fault. See?
Well, it might be. I wasn't there. I mean, what if she says that, okay, I put, the cap on tight? I don't know. I don't know what she's going to say.
That's why we need the surveillance video so we can find out who's at fault. Because you can't visually inspect that cup and see whether it was put on there securely or not. But we know it shouldn't have fell off as easy as it did. Okay, now talking to Charlotte said she was able to see the surveillance video and she said the girl passed it to you. It came inside of your car. That's where the incident happened. So if Charlotte from the insurance company can tell me all that from a video she's seen, well, I need to see that video, and so does the court. So we can determine who is at fault. Once we determine that, and if it does come back and it shows the video, oh, Mr. McNeely, you did this or you did that, I'll say, okay, I see that now. Okay, done deal. I'll accept liability, but I don't believe I've done anything wrong.
Okay, that's fair.
So we need to put all the evidence out there.
Okay.
I believe I wouldn't have never went to the hospital. I didn't get up that morning thinking I'm going to go to the hospital, blood pressure 252, up in the 200s. That wasn't my plan when I got up that morning.
No, I'm sure it wasn't. No. And no company wants their customer to have to go through that.
And then there's a problem where she doesn't even apologize. She's like, oh, good for you. She's like, yeah, I thought the shit was funny. And then she comes, a month later, she comes and she's taunting me. No, something's got to be compensated for that. That's bullshit. No, we got to be compensated for that. We got to make sure that the employer knows what his employees are doing and that he makes sure this doesn't happen again. So, no, I'm not just going to roll over.
Okay, I can understand. Your position.
And then there's the part I can't even make a fist with the hand anymore. So no, there's pain and suffering there. So, I mean,
all right. We'll talk about it some more. We'll, hopefully we'll get. I don't know if we're going to need to do the deposition, but if we need to, we could do that. And then, you want to see the video, and then we'll arrange for that.
Well, I mean, you guys keep getting it twisted. I'm asking for a copy. I'm asking for a copy of the surveillance video. And you and your client have a duty to turn that over. That's Brady versus Maryland. That's a Supreme Court case.
Okay.
You can't conceal evidence from the plaintiff or the court.
All right.
So I requested 2 subpoenas on that surveillance video. And now you say, oh, we'll show it. No, I'm asking for a copy. You have a duty to turn that over.
Okay. Copy.
I've put this type of language in my paperwork.
Okay. Okay. Well, let me work on the discovery issues, and we will talk, and hopefully we can come up with something that will work for you.
Sounds good.
All right. Hey, thanks, Dillard.
Appreciate your time.
Okay, no, same here. Thank you. Thanks for your patience. I appreciate it. I know that it takes a long time, and I apologize. The court process is difficult, and we're busy and you're busy, but it's not because I want to delay things. If I had full control over everything and working on so many cases, I would hope that we would have resolved it already. But the court process,
Well, I agree with you that this isn't a difficult case. I agree with you on that.
I agree. Yeah, because the facts are simple, and that's why when the court said, "Oh, this is complicated, we're sending it to Torrance," it didn't make any sense to me.
Well, it makes sense when you're talking about jurisdiction.
Yeah, but they didn't say that. That's the thing. They could have said, "This is jurisdictional."
You're an attorney. You're an attorney. You already know that. You went to school for law, so you know jurisdiction is very important.
Well, I know, but the court didn't say that. That's the thing. I know you're saying that, and it might be true.
They call it inferred. They call it inferred. A lot of times attorneys get up there and they infer things. And so you have to be able to pick up on when someone is inferring something. She's inferring that she's not allowed to deal with that case because it's out of her jurisdiction. That's what I took it as. She was inferring.
Maybe, but it was to me, it was a really confusing way to put it. And I'm not, because I worked with a different court, and it doesn't make any sense to me the way they handle it. But anyways, I don't want to, that's fine.
I mean,
right.
that kind of fraud upon the court is good for the attorney as long as the plaintiff doesn't discover the fraud that's been committed on him. But once he finds out that that's a void judgment, he can go back 10, 20, 30 years from now and bring that case back and have it overturned because it's a void judgment, and anything happened in that jurisdiction, that case is not binding. So, yeah, so attorneys love stuff like that. Oh, yeah, let's do it over here. And,
Well, it must be other attorneys. To me, I don't necessarily agree with.
Once you learn what attorney, once you learn fraud upon the court, what attorney can and cannot do, it kind of makes this thing a lot more easier for you because you sort of looks out for what that attorney can and cannot do. And then once you learn what he can and cannot do, then you say, hey, objection, Your Honor. Well, he's an attorney. He can't be an attorney and a witness in the same case. That's rule 3.7. Can't be an advocate and a witness in the same case. So you can object to that. And she doesn't. And she takes his statement as facts. You can overturn it in the federal court. You know that. That's why that case I got going on now in the Ninth Circuit. Cannot be an advocate and a witness in the same case. Can't do it. You got to have that.
Generally not. Generally, because of conflict.
Yeah, you got to have that witness there. Right. So if the plaintiff's over there with his attorney, so you have the plaintiff and his attorney, and the defendant is supposed to be standing over there with the defendant and his client. If his client doesn't come in, the court never have jurisdiction. That's a three-legged table. It ain't gonna fly. That's Trinity versus Pacalaro. They've been pulling that stunt on us for the last 50 years. And getting away with it until the person wake up one day and say, hey, got fraud up on the court here. So, pays to read. So, I'm standing my ground to make sure that doesn't happen to me again.
Okay. Well, I think you made it clear, and I appreciate that.
Yeah. So, yeah, you can get with your boss and find out if he's willing to come up off his numbers for the pain and suffering and the aggravation and this injury being worse and everything. We can go ahead and nip this in the bud and get it out of the way. I don't want to be going in circles no more than you guys want to.
Okay. No, I appreciate that, and I don't want to waste your time. Well, we'll do our best to come up with something that works for everybody. I hope we can. I'm going to try my best.
I appreciate that.
Okay. You have a good day, Dillard, and nice talking to you.
You too. I'm gone. Thanks.
All right. Take care. Bye-bye.
Bye.